Welcome to Shenkman Education. My name is Marty Shenkman, and this is a case study on using trusts and asset protection. What I thought was interesting about this discussion with somebody about using trust for asset protection is it's a good illustration of how there's a continuum from little asset protection to much better asset protection, a lot of stops in between. And you need to pick what works for you because there's different costs, complexity, different degrees of worries about asset protection. What is asset protection? Worrying about lawsuits, claims, divorce, and so on. So mom set up a trust for dad, and when dad passes, the trust, and mom and dad pass, the trust breaks up into separate trusts for each of their 4 kids. So what's the problem? Dad realized, mom realized, gee, are we really protecting the kids well enough with these trusts? And the issue is the way the trusts are written was that at age 25, the kids get the money outright. The thought was, golly, when the kids are 25, they should be mature enough, give them the money. It's a lot of money in this case, and they had some reservations about what they had done. So the question is how to fix it. First, in a general way, don't set up trusts at a specified age. Have the trust go on as long as state law permits. It doesn't mean that the beneficiary, whether it's a child, grandchild, or somebody else, can't get at the money. It means you're protecting the money. So we're going to go through the sequence. Paying outright, which is kind of what happens at age 25, is really no protection from that point on. It theoretically might be treated as separate property if there's a divorce of a child, but it's so easy to commingle or mix with marital assets that that protection could be lost. Second, if you can have better protection, why not? Also, it does give some protection until the child's 25, but that's before they start working in their career and get on in life when the real liability issues tend to arise. So you could change this trust by decanting or merging it into a new trust. And then the other thing you can do is you can have that trust go on for as long as state law permits and have the kid be their own trustee. Because if their own trustee, if the parent really wanted to give it outright but have some protection, having the kid as their own trustee gives them pretty much the maximum control. There's a limitation that you have to restrict what the kid as a trustee can distribute to the child themselves according to health, education, maintenance, and support. It's often called by the acronym HEMS, H-E-M-S. It's not 100% sure in every state that if you have a HEMS distribution and you're your own trustee, that you're going to really prevent a creditor from getting at it. I'd be concerned that a court's going to come in and say, hey, kid, you're the trustee, you can make a distribution to support yourself, and your alimony payment, that's part of your support. Your child support, that's part of your own support, you got to pay it. So I'm not sure that's really maximum protection, but it's a lot better than nothing, and will protect against some claims. Another step improved is you name an independent trustee. Then it's not the child having control. You don't need the HEMS limit. It could be totally discretionary, which is more asset protection. The thing you could go beyond that is you can name a professional or institutional trustee. If you name a professional or an institutional trustee, it's professionally managed, probably a lot better and safer and better done than if you have a child doing it themselves or any individual that doesn't really have the skill set to do it. Also, if you have an institutional trustee, trust company, bank, etc., that's really infusing a degree of professionalism and independence into the planning. What can you do further? Let's say you're even more concerned. You can move the trust from the state you're in to a new jurisdiction. Alaska, Nevada, South Dakota, there's about 20 states that have more favorable laws for asset protection and permit self-settled trust. This is not a self-settled trust, but there's a tendency by most advisors, I think, to want to be in one of those better states. So they can move the trust to that state and decant it into a new trust with these provisions. That's even a better result and likely to be safer. And it has the institution. And it has a discretionary distribution. No standard like HEMS that a court might interpret in a negative way from an asset protection perspective. Final step. What you might do is create a trust in the new What you might do is move the trust from your home state to one of these asset trust friendly jurisdictions, naming as a trustee an institutional trustee, and let them decant or merge that trust into a new trust, because then it's not even you handling or effectuating the merger. That may be good from an estate tax perspective as well, because if you created the trust and now you create a new trust and you as trustee, or your spouse as trustee rather, merges the old trust into the new trust, are you kind of indirectly orchestrating all this and exerting control? If an independent institutional trustee effectuates the merger, the decanting, I think you avoid that as well. So I thought this was a good case study to illustrate how you can take what I would call a not well thought out trust that pays everything outright at a certain age to a kid and step by step improve it. And it demonstrates that there's a pretty wide continuum on which you can plan. And where you go on that continuum in terms of cost, complexity, steps, depends on how worried you are, how concerned you are about estate taxes or asset protection. But it illustrates how you should be in charge and in control of making decisions if you get the options. And there's often a number of options to accomplish an estate planning goal. Thank you for joining me, and please keep in mind that any video clips are for educational purposes only. Don't take any action without appropriate professional advice. For more information, see Shenkman education.com. Thank you.